Hi, I'm Helen Webster. Welcome to part 2 of my virtual book launch. In part 1, I talked about why I needed to write this book, why it was so important to me and to the lawyers involved. Part 2, which is actually almost 2/3 of the book, deals with the legal proceedings. Before the book went to publication, I had a number of close friends who I deeply appreciate read the manuscript and give me their comments. One of the comments that came back was from, she was a teacher, and she read the book and she was, as we all are, shocked by the first part of the book. And then she told me that when she got to the trial, the legal proceedings, she said, I thought this was going to be really boring. And it wasn't. She said, I couldn't put it down. I wanted to know what was going to happen next, what the lawyers for the prosecution would say, how the defense would counter. She told me that she had never sat through a real trial. So for her, it was really an eye-opener. And she enjoyed it. Whether or not she was happy with the verdict at the end, I don't know. But part 2 of this virtual book launch is going to deal with the legal proceedings. Before I start though, I do need to tell you that if you wish to buy the book from, say, Friesen Press, or from a bricks and mortar bookstore, whatever it may happen to be, you'll need to know the categories of the book that the book will be shelved under. The first one is true crime. The second one is family and relationships. And the third one is simply law. So you should be able to find the book in any one of those 3 categories. I'm going to talk about the book today, the actual structure of the book. As I've said, 2/3 of it deals with the legal proceedings. But if I went into a bookstore and was looking at a book, the first thing I would do would be look at the back of the book. And I would read it. And it says here on the back of the book, the legal proceedings that form the basis of this book are fascinating, and they are. The reader, that's you, will be enthralled by the courtroom arguments as the Crown Prosecutors, who charged this child's mother and father with murder, sought justice for Susan, while the defense team sought to defend her parents from this terrible accusation. Right away, I want to know what happened. Some readers may find the verdict and sentence unsatisfactory. Others may conclude that the justice system operated as it should. Was this child's death intentional? As the author, I didn't attempt to second-guess the results of the trial, but simply presented the evidence and the legal arguments, leaving you, the reader, to decide. Now I'm going to look at the inside of the book, because that's the next thing I do when I'm looking for a book. I look for what people had to say about the book. Those are under pre-publication reviews, and I'm not going to read the whole thing out loud, but I'm going to read the second paragraph of this particular one. Webster, that's me, leads the reader through the thoughts and words of sparring lawyers, while thoughtfully and effectively cutting through the legalese of a court trial. The reader is given a shocking, awakening glimpse of child abuse and the strict protocol of our justice system. As I read this book, I found myself appalled, saddened, and deeply invested in justice for Susan. Never having attended a trial, this book gave me a good insight into how the legal system works in our country. And this pre-reader said, copies of this book should go to the justice ministers of the provinces and of Canada. I think so too. Now I'm going to take you in the book to page 88, and I'm going to tell you a little bit about, I'm going to describe the judge in the first preliminary hearing. Judge Yates was good at his job. An ex-RCMP non-commissioned officer from Northern Canada, he had been highly regarded by his peers in his previous occupation. However, Judge Yates had not trained as a lawyer and as such was considered a lay judge. Now, a lay judge is simply a judge who does not have formal legal training. There are no longer lay judges in Canada. You may be familiar with the idea of the English magistrate, who was usually the wealthiest or the most prominent citizen of a community, and as such was in charge of looking at any legal matters. A lay judge in Canada held much the same role, but in the late 70s, early 80s, there was a legal commission called the Kirby Commission, in which it was decided that there would no longer be lay judges. All judges in Canada from that date have to have legal training. And most of them have trained and acted as lawyers either for the prosecution or the defense in court cases. However, Judge Yates, though he had not trained as a lawyer, was honest and judicious and was determined to give every person who came before him a fair hearing. The defense lawyers continually tried to take advantage of the judge's lack of legal training, but Judge Yates took no nonsense from the defense. He was careful to avoid making an appealable mistake. He knew that the Crown attorney and his co-counsel for the prosecution would provide the points of law that would prevent the defense from getting away with this ploy. It was frequently necessary for the Crown attorney to remind the defense that this was not a trial and that there was no jury to impress. Nevertheless, the defense attorneys continued their delaying tactics throughout this preliminary inquiry. So the preliminary inquiry ends, and we go on now to the spectators leaving the courtroom. I hope when you're reading this book that you will think of yourself as a spectator at the preliminary inquiry and at the trial, because you have all the information that they have, and you're sitting right there watching the lawyers, watching the judge. As the spectators filed out of the courtroom into the February chill, the conversations were loud and often argumentative. How come that lawyer could be so rude to that witness? What was the point of all the time spent if there was no verdict? Do they have to do it all again? What an expense. There were even those who were sure that the parents had murdered their daughter and wondered why a trial was even necessary to prove something that seemed so obvious to them. Some of them lived near the family and were aghast that this had been happening and nothing had been done about it, blaming the neighbors who had looked the other way, who had not followed up on their original complaints. There was strong disapproval of the social services and the public health unit, who they said had ignored the child's unhappy life. A very few of the spectators felt sorry for what the parents were going through. Another group was not so sure it had been murder and stated firmly that it was just discipline of a poorly behaved child that had been perhaps too strict. The community was divided in its opinion. Feelings ran high, and everyone, no matter which side they supported, hoped the trial would be soon. It would be good to get this all over with. so that life could return to normal. Between the preliminary hearing and the trial, there was the year of adjournments, and it was almost a year. I'm not going to read from that, but I'm going to take you on now to the actual beginning of the trial. Chapter 16, the trial. This is more than, well, it's probably about half the book. So, chapter 16, the charge is murder 1. This is the first day. And here's a quotation from Robert F. Kennedy. I am deeply impressed with the gravity and wisdom with which most judges approach the heavy responsibility of sentencing. It is a difficult and soul-searching task at best. The courtroom where the trial would be held was on the second floor of the Drumheller Courthouse and was much larger than the downstairs room where the preliminary inquiry had been held. On the October morning when the trial began, rays of late autumn sunshine streamed through the large windows, filling the room with a warm light. The sunlight glowed on the raised paneled bench, behind which the presiding judge, the Honorable Mr. Justice W.J.C. Kirby, would sit. From this high position, he would overlook the prisoner's box, the attorney's tables, and the rows of benches set behind a low railing that were available for the public. There was room in the spectators' gallery for close to 50, and this morning every bench was filled with curious members of the community. Many of these people were from Midland Vale, a suburb of Drumheller, and many of them knew Harold and Linda Myrby, the parents of the child. Frequent sideways glances were directed to the prisoner's box, where the couple sat, awaiting the beginning of the trial. Harold appeared to be anxious. His face was pale, and he twisted his hands together. Linda was impassive, her facial expression blank, showing no emotion. Then the clerk of the court entered and asked all to rise. Then Mr. Justice Kirby entered and settled himself in his seat behind the bench. Justice Kirby was both liked and respected by the lawyers who appeared before him. All of them knew he was well versed in the law and wise in his understanding of lawyers, both young and old. He was calm and composed in his conduct of the proceedings, and was well known to the legal community that he worked very hard to be a good judge. Physically, he was of average height and weight, but when he sat behind the bench overlooking the courtroom, his upright posture, his lean, unsmiling face with its slightly hooked nose, and his imposing head of wavy gray hair all combined to impress everyone with his command of the courtroom. There was no mistaking the gravity of today's proceedings, and Justice Kirby's solemn demeanor suggested clearly that there would be no more delays. The trial continues and goes on, and this page talks about how the prosecuting attorneys summarized their words, what they had said. The demeanor of all the witnesses had been forthright and candid. They had not been shaken in any way in their evidence. The occasional small differences in evidence from the preliminary inquiry were understandable, as nearly a year had passed. The accused were not under arrest, but were out on bail. The police officers could not have put words in the mouths of the accused, as the police had not yet known what had happened. Harold Myrby had not been abused by authority. He himself gave an explanation of his faint, and he had twice declined the services of a doctor. Harold's statement was just that, not a confession, but a statement of what had happened. The Crown Attorney finished his summation by saying, "I submit that there is nothing that takes away from the voluntariness in the statements. Thank you, my lord." I want to talk for just a moment about voluntariness. In a trial of this nature, in a trial of any nature, the statements given by the accused must be proven to be voluntary. In other words, there had been no pressure or any reason why the accused would give a statement that was not true. A lot of the time in this trial is spent on proving that the statements were voluntary. And I'm going to leave it at that now and just say I hope I have intrigued you by reading you these sections from what was a fascinating trial. And as I said right at the beginning, when I wrote this book, when I put this trial down for you to read, I, as the author, made no decisions on the verdict and the sentence. You will have to decide.